have a few rules that we have to look at in section 9 and 10 as well. I want to talk briefly about, have you direct your focus a little bit to it, and then we'll turn to the section 10 cases. But if you look at section 9, we were supposed to discuss 26 and 27, rules 26 and 27, which are the start of discovery, and we will do so. And then this week we're supposed to talk a little bit about rules 5 and 6, which deal with service of pleadings and the computation of time to respond and the like. First, rules 26 and 27 deal with how discovery begins and what the proper scope of discovery is, and that those are the same rule numbers whether we're in Massachusetts or federal court. And so when we start to think about the scope of discovery in 26, the standard that we generally use is anything that is relevant or that which might lead to relevant evidence which is not otherwise privileged. So those of you that have already had evidence recognize that one of the standards for admissibility of evidence is whether the information is relevant. But the scope of discovery goes beyond what simply is relevant and says it's either relevant or that which will lead to discoverable evidence. So we can obtain information from more sources than what ultimately might find its way to be relevant and admissible at trial. So in essence, it's been described in other ways as it is a fishing expedition to some extent, and the question is where you get to fish, and the fact is that you will be allowed some latitude there because you don't have to prove the information is relevant or admissible at trial. All you have to do is prove that it may lead to relevant evidence, and it's not otherwise privileged, which is the other part of Rule 26, is obviously I don't have an obligation to provide you with privileged information that I can legitimately withhold from you. What we do have to do, though, is that if documents are withheld, or what I do have to do if demanded of me, is if I am withholding documents under a claim of privilege, then at some point, if you request, I should be required to produce what's called a privilege log. And the privilege log is a description of the documents that are being withheld under the claim of privilege. And it's been my experience is that that's where sometimes abuses take place because people try to hide important information under a claim of privilege that isn't always a legitimate claim, but is an effort to try and prevent important information from seeing the light of day. So you've got to be careful with it, and it sounds terrible to suggest that the other lawyer or parties could be in collusion trying to keep important information, likely sufficiently important that it could be dispositive of the case, from you under some form of claim of privilege. But obviously we would do the same if in fact there's a legitimate claim of privilege. And I'm not concerned about legitimate claims of privilege. What I'm concerned about is the oftentimes more frequent practice of creating a privilege claim simply to try and prevent the disclosure of important evidence in the case, and that you've got to carefully watch with that information. The other part of Rule 26 talks about is the disclosure of. I'm sorry.
No, I just wanted to ask. When one side's claiming there's a privilege and the other side is trying to insist that there's not, is a separate hearing held on the matter?
This is why it becomes very difficult. Yes, there is, but even to get us to the hearing stage, just think of it logically. First, I have to know such documents exist, and it's not always documents. Sometimes I had an important tape recording in one case where the attorney actually recorded it was an invention case, and he recorded the transaction between the two inventors and himself so that he could then know, because it was highly technical. It was a cardiac catheter. And so that he would then be able to know exactly what the language was that they were describing to him and everything else. So it's not always documents. There are other forms of things, like a tape recording or other things along those lines that could fall under claim of privilege. Here's the problem. I don't know they exist at all unless in response to the request for production of documents and things, and there is a reference there that I'm giving you this, but withholding things under a claim of privilege. And almost all responses to requests for production of documents have boilerplate languages that say we're producing everything but that which is being withheld under a claim of privilege. Well, okay, it is sort of boilerplate. I can blow past it. But if I don't take the next step, if you don't take the next step and say, okay, if I want them in writing, either assurances that's boilerplate language, nothing is being withheld from you under a claim of privilege, or if things are being withheld, I want a privilege log. Because until I have one or the other, I don't know whether we have a problem. When I get the privilege log and I look at it, I'm going to get a brief description of the information that's being withheld. By that, typically, the date of the information, whether it's a document or tape recording, the participants, whether it's the sender and recipient, and then beyond that, a very vague general description. Tape recording, conference with client. That's it. I'm not going to say conference with client, Ray, invention, and how it came about, because I don't want to provide you enough information where you're going to have a basis to take that next step and ask to compel that it be turned over and for some type of in-camera hearing. So it's a general description. And at that point, I, as the person seeking the information, have a difficult road, in essence, to go in order to show that, the document's clearly relevant. So it's not whether it's in whether it's in the scope of discovery. The question is it a legitimate claim of privilege? And I don't know enough at that point. And so the way the process would normally work is that you would seek to compel its production, arguing that it isn't appropriately privileged. They're going to argue it is. At that point, the review of that information, if you're lucky, in the first instance, will take place in camera, in chambers, and no one will be present. And so I'm still left in the dark as to how valid the claim of privilege is, and I have to trust the judge in looking at that. First, I have to trust that the judge will order, I'm going to examine it in camera. And then B, having examined it, which that in-camera examination could say, I've examined it, it's a legitimate claim of privilege, you don't get any of it. Or, I am concerned about whether it's privileged, we're going to have a further hearing on it. I still won't get access to it until it's turned over because of the concern about my getting access to privileged information. So in some ways, it's a big catch-22. Because I've got to make the claim and successfully argue it's not privileged without knowing what the contents of it are. In my case with the tape recording, that's relatively easy at that point, because in essence what you've got now is a situation of they were co-clients at the time the tape recording was made, but now they had a falling out because one stole the patent from the other by making believe that the product was useless when it was never useless. And so in the situation of co-clients suing one another, there clearly is no privilege for those communications that take place. As to strangers, there is. But so that's a relatively easy one to obtain. But there are other situations where you know that is important information, but if it's legitimately privileged, then it may well end there, because I'm at a real difficult I'm in a real difficult situation to successfully argue it's not privileged without knowing what it says, without knowing the details of it, but that's the way the process has to be done.
So it's kind of two steps. The first step would be to try to fish enough information to get the judge to look at it.
Yeah, and part of that really starts with, I need to know, A, are you withholding anything under claim of privilege?
Generally, you could kind of like guess, like if you're not like kind of in that situation, you could say any tape recordings or documents that pertain to a conversation your client had about patent X or something like that. That's a fishing expedition, but it might be enough to get the judge to look at it to see if it's privileged.
Well, but wait a minute though. The first part though is simply a request for production of documents. I want all documents, tape recording. You define documents broadly with respect to the invention of X device, and so then they would respond to that request saying, well, here's everything. And probably a general one saying, we're producing everything we have responsive to request 1 to 20, except such items as being withheld under claim of privilege. You have to follow that up and say, I want to know. And sometimes people say, no, we're not withholding anything to you orally. That's not good enough. That's not good enough in a year from now. Then say that, either give me a writing to that effect or produce a privilege log. Because down the road, that conversation gets lost. If you're dealing with someone that would otherwise hide information along these lines from you, then what would lead you to believe that you can accept them at their word with words that later on down the line it'll be, I never said that, or I told you specifically, no, that wasn't true, we're withholding stuff. I mean, that's the problem, is in our business, oftentimes we have to document everything, and especially protect our back against later down the road where oral assurances that were given are not honored now, and we're not truthful at the initial point in time. It's a different story if we've got the documents in writing, and if I got a letter saying we're not withholding, and that's all I'll say as a general matter. Just give me a letter that says we're not withholding anything despite the response to the request for production, or we are, and here's the privilege log, because that's the requirement. If you do, give me the log. And then from the log I can try and take a look. It's still an uphill battle, but there'll be some cases where there's an awful lot of information on the log, and it appears that it's going to, you look at it, and the recipients are people other than clients. Well, that's not an attorney-client conversation then. So now you're going to try and make the arguments work product. Well, work product has different rules as to whether I can get access. And so some of that will help, and the timeline will help to establish some of it. But at the end of the day, I am hoping to try and force the court's hand to at least look at the documents themselves to make the determination whether it's legitimately being withheld or whether they are preventing access to the information. A common device these days, especially for larger corporations, is to put an attorney in the room in a meeting like this, simply to provide legal advice if necessary. But what they're really trying to do is keep the information that the board of directors or other officers talk about from ever being able to be inquired about during depositions, because the argument is, well, that was a privileged communication that took place throughout that conference. It's what I call a privilege bath. Is you run it through the attorneys, or the attorneys present in the room, the argument is everything that took place falls within that. And that's a very broad and I think incorrect analysis of the attorney-client privilege, but that's where it's done. This is where stuff is hidden, is within that. But legitimately, you are not required to turn over attorney-client privilege information. What you do have to do, though, is produce some information at some point about your experts that you're calling, who will be testifying, and that's contained within Rule 26. And they make a distinction, if you look at 26, between experts who are testifying, experts who have not provided a written report, experts who have provided a written report, experts informally consulted but not retained. And this becomes important, too, in our litigation strategies, because if I have paid an expert, I do not want to see them on the other side's list testifying against me. Because one of the ways we principally impeach experts is by showing that the party who is now producing them to testify on their behalf has paid them for that service in the testimony. If not, on the other hand, the party against whom they're testifying is the one that originally brought them into the case and paid them, you can't have much better testimony than that come in, and it hasn't cost me a dime. I mean, that's like an absolute home run. So this becomes important as you start to select experts and decide, but at some point that information does have to be disclosed as well. And then importantly, in federal court, before any discovery can begin, there has to be a voluntary exchange of information with respect to the mandatory disclosures that are now required in federal court. The names of the potential witnesses, the location of evidence, what the valuation of the case is. In federal court, we have the rule which is designed to try and prevent these paper battles that become civil litigation, just sort of a grind in the other side to the point where they decide to walk away, or it gets so damn expensive that they have to settle for less than they might otherwise, where the federal court has instituted measures to try and prevent some of that. But at the end of the day, in most major pieces of litigation, we're going to spend months and months on discovery. And it's a huge expense. Obviously, it's a vital requirement in order to be successful. But I often use the expression in discovery, it's not the first box of documents I get that are likely to be important, because the other side is likely to try and prevent my access to the really important stuff. It's the last box of documents that's important. It's the box that shows up on the day of the deposition, or a month before we're supposed to finish all discovery, and all of a sudden the treasure trove of documents that I've been expecting and knowing exist finally show up. And so what that means is, through the course of discovery, you got to dot your I's, you got to cross your T's, you got to look at your request, you got to make sure the responses are responsive to the request, and if there is information missing, as there often is, you need to follow that up in writing by telling them, I've reviewed this, I know the following exists somewhere, or did, where is it? And that's the other part of it. Sometimes things will no longer exist. You need to document that. If information has been destroyed or lost, negligently or intentionally, once litigation was likely, or once litigation began, then in many jurisdictions, Massachusetts specifically, you are entitled to a spoliation instruction. And what that means is that the evidence that has been lost or destroyed was harmful to the party who had control over it. And that, in and of itself, might be enough to get you past a motion for a directed verdict and get you to a jury analysis. And we see it more and more, and it's not just with electronic information, but obviously the ease of getting rid of electronic information raises new issues in this regard. Lastly, we've got Rule 27, depositions to perpetuate testimony. There will be some times where we are not in a position to institute suit because we don't have the required information, or a party or an individual may likely die sooner than we may be ready to file our case. You actually can, through Rule 27, file a petition to take depositions in advance, to do some discovery even in advance of the suit, in order to preserve that information for trial, and that can be helpful as well. I would just tell you to start to think about this rule as well by adding in your evidentiary rules that you're aware of, because obviously you would be better off filing your suit, deposing that witness during the pending suit, because then the adversary will likely have counsel and will have the opportunity for cross. You now have a deposition that's taken during the trial. The witness is no longer available through death or whatever. At that point, the likelihood is almost a certainty that you will be able to use that deposition at trial. If you simply take it in advance of trial and you do not have the adversary's who that deposition may ultimately be offered against, you may find yourself in the same conundrum you started with in trying to get that admissible at trial. So that becomes an issue as well, but it is a way to preserve testimony pending trial. Lastly, we're supposed to look at Rules 5 and 6 today, and 5 and 6 become important, and especially important as you start to compute time and start to think about when papers are filed, who's supposed to get copies of them and the like. And the other thing I'm going to add to this is the whole idea, which is more so for you than in earlier times, that documents are also often filed now in a federal court, required to be filed virtually exclusively electronically. And so when we serve papers as well, it's not just serving them on the court, but who else gets copies of the information, who's entitled to it. That's Rule 5, is that you file the matter with the court, but the parties obviously are entitled to receive copies of that along with your certificate of service and the like, so that we know that all the various defendants have access to the same information. And the other part of this is with respect to Rule 6, and there's more privacy information within these rules as you start to look at them now. Was I in federal court? I was. And there's a little sheet on the table that talks about, even in the transcripts now, some of the identifying information that one time was so easily provided, such as social security numbers and specific dates of birth and things like that. That's not supposed to go into the transcript, and you're not supposed to file some of that information in court. And there may be times, if you look at Rule 5, that you want some of this information filed under seal. But not just because you may want it under seal doesn't mean it gets to. Under seal simply means it is harder for the other side, for anyone, to get access to it. Because beyond that, documents you file in court or filed against you in court are public records. And the fact is, we could go online from here to the federal court database, and we could pull up virtually any case we want and look at the complaint and the answer and anything else that's been filed in court. We could run Patrick's name and see if he's ever been sued in federal court in Boston here and find out what we can. And that actually looks specifically at the pleadings, and there is, and it is in large measure because of the First Amendment, but also if you start to think about it, so does that mean if my date of birth, my social security number could be filed as part of these complaints and things? Sometimes. And so if we're worried about identity theft or we're just worried about our own privacy, some of these things become issues, and those are simple things. Businesses want to preserve their trade secrets and the like, and some people just simply want to preserve their reputation, their image, because oftentimes there are things people sue because of potentially scandalous things, and obviously you have the right to file your complaint, but to what extent does that potentially injure my reputation?
Do you find with the increase of identity theft that more and more people are filing under seal?
No, I don't think it gives them the right to file necessarily under seal. What it does mean is that you as the lawyers, and specifically the court, is more careful now about some of that confidential information that at one point we wouldn't have really given much thought to. Well, there's no, Kelly Tiller born April, whatever, blah, 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 blah. That the dates of birth, those types of things, even one could argue in some instances your specific street address is a private information that you might not want, well, you certainly might not want others to have access to. The question is should they? Under seal, the standard is raised because there is, and especially in some of the more sensational cases, you see the newspapers come in to say, well, why is it under seal? What gives it that level that we shouldn't have access to it? Because the Constitution favors the presumption of an open trial process, an open court system, which I think from almost all things is a good thing. I'll leave it at that. I think it is. I'm thinking, because I see it as an abuse sometimes where they too quickly either allow the sealing of the file or allow people to proceed. There was a case in Boston about a year and a half ago now where someone, a wealthy businessman, sought declaratory relief anonymously because he was allegedly being extorted by, and I don't know who it was, because of some private sexual peccadillos that he had engaged in. And the court did accept it under seal and treated it that way. And it struck me as the person had to be pretty hardwired to be able to accomplish that, because again, the process as a general matter favors open access to that information. On the other side of it, if in fact the information was false and there were scandalous things of significant nature in there, you don't get your reputation back either. But where's Kelly go when she was falsely arrested for shoplifting, or any of you go when you've been falsely arrested for assault and battery on a police officer? That's the risk we take. So Rule 5. Rule 6 is important because it is the process for computing time. How much time do we have to respond to certain information? Because sometimes you get a request for this or that, or you get a motion, and now we've got to compute how many days do I have? Do I have 10? Do I have 7? Do I have 20? Am I working this weekend or not, is how it impacts you. And so when we look at Rule 6, it talks about whether we use the weekend days to compute your time for response, how you would go about obtaining additional time, and there will be times where you cannot respond within this sufficient amount within the time established. Then you likely will call the other side, request an extension. They may or may not say yes, and if they don't, you need to know that Rule 6 allows you to go into court and get that extension, but don't wait till after the fact. Lawyers have time deadlines that they have to comply with. If you cannot comply with time deadlines, you don't belong in this profession. And if you look at Rule 6, it will allow you on those rare occasions where you can't meet the deadline or there are other issues that are raised by it that you need the additional time for you to get it. But what you really need to know, and I hope I've stressed this, and I know I've stressed it for some of you in other courses we've had, is that, you know, the dog ate my homework, all the rest of the usual BS that some of your colleagues still try to pull. You cannot do that in our profession. Deadlines have to be met, but it's also important to figure out what the deadline is, because there will be people. Judge Agnes and I were working on this little thing this weekend. You know, there are lawyers who will fax stuff into you on Friday afternoon late, simply to make havoc of your weekend. You know, I mean, all things being considered, I'd rather serve you on the Friday than the Monday, simply because the clock's going to start running as we look at this. But you couldn't do Thursday. I mean, you don't have to be the ultimate brick, right? You could do Thursday instead, so the clock runs a little earlier. But that becomes important as we start to think, and as you guys start to think about professionalism, civility, and all the rest of it. How can we be at least a little more reasonable about the cooperation on some of these issues? And frankly, there are times where you're not going to get any cooperation. So now I need to know how to compute Rule 6, and in the event we have a disagreement that you're not going to give me that extension of time, then I'll go over to court and ask it. And listen, here's the other thing. If I generally meet my deadlines, and I'm not the guy in court every other week asking for the extension, or asking for the extension after the fact, after the time has lapsed, then the court's going to cut me slack, and they're actually going to look at you and say, you couldn't give him another week, couldn't give him 2 weeks. I mean, that's the other part of it. You're asking for a week or two? You're asking for 3-4 months? There's a huge difference into what is reasonable and what isn't. But Rule 6 at the end of the day is how you're going to compute that time and how that time will be impacted as you start to look at it. The last statute in this Section 10 is 209. Oh, yeah, go ahead.
Yeah, can I ask just a real quick clarification? So if I have 20 days to answer the complaint as the defendant.
Yes. You use Saturdays and Sundays then.
Correct. And then if it's less than, and then a reply to the backwards reply is only 10 days, so that does count weekend days because it's less than 11.
What backwards reply
So
are you talking about?
a 10-day reply to a counter motion or whatever. You get,
Oh,
so that's a 10-day, right?
the response to the motion, whatever the motion is, the motion and memo.
So
Yeah.
that would count. You could get the weekend days here because it's less than 11. That's what this
Yes, exactly, and that's why when you start that, and listen, whatever the rule is going to be at the time, you need to go to 6, and that's the thing, is because there will be times where there'll be a lot of times where you got to look at this rule and say, okay, how many days do I have? Because if I've got a straight 7, that really is not a lot of time, and there's very few things that are straight 7. Some are though, and that includes the weekend days. And so if I take the next 2 days off, I only got 5 days left to get it done. And to write a memo and respond, depending on what it is, you're going to be cutting it a little bit close as you get to the end. And by the way, this isn't your only case, right? You might have another trial scheduled for Monday or Tuesday, or you might have, you have more than this response to do in all likelihood. I don't know what your caseload will be, but I can guarantee you it's more than one. So you're not just juggling this file, you're oftentimes juggling many, many, many more. And so that's where this becomes even harder. But again, I think the court recognizes that if if you're engaged in a trial, the court will cut you some slack. But suppose it's like a lot of trials. It's a 1 day. And so you got another 4 days, as the court would see it, right? I mean, you got to juggle a lot. But you got to know how to compute the time too, because I like my weekends, and I'm sure you like at least a Sunday off. We're going to watch some basketball this weekend, right? So go ahead.
Going back to Rule 27.
Yeah.
Is that ever used kind of offensively, like an aggressive manner, like you get authorized to get pre-action depositions? Does it use that?
I haven't seen it used that much. I've probably seen it used maybe a handful of times in like 25 years at this point. Actually, 25, 30 years now. You do see it. It's usually it may be in order to try and obtain additional information so you're comfortable satisfying Rule 11. Other times, what you're really worried about is that the person may be so seriously ill that they will not survive to trial, and I got to try any effort to preserve this testimony. That's more likely where you've seen it. And the other part of the case may just not be sufficiently ready to file the complaint yet. It's just we're waiting for the final damage study, or if it's a medical case, the person to be at an end result, and that's going to be another 6 months. And so that may be the situation there. I really haven't seen it used, but a lot of my cases are business litigation cases. I have not seen it where I would say it's been abused, because the process is a little funky too. It's not, you're going to go into court and they're going to look at you like, well, what action is this? And it's not really an action yet. So it's not a common thing that's used or abused.
Yeah, when I read it, it struck me as like it could be used improperly.
No, I haven't seen it really done that way. Anything else? You know what and we spent a lot of time on these tonight, but at some point before you're done, you really need to have a more thorough understanding of how each rule relates. We never talked about Rule 5, probably never talked about Rule 6 when we did CIPRO. But out in practice, you got to start to look at them with a much finer eye. I mean, remember, I can't tell you how many times I looked at Rule 6, because I'm constantly getting stuff, and you're looking, and it's like you're saying, okay, so 20 days I'm good. 7 days, 7 days from this court, is it just this rule, or is there a local rule within the court that I've got to look at as well? Because it's your own time management and your own schedule that at the end of the day is impacted. And you can't miss deadlines in our business. So you got to make sure you've read it right and are comfortable that, Saturday's not counting here, the holiday doesn't count. Oh, look, frankly, it's as you pointed out, at some point you realize, 7 is almost better than 10. Because 7, you don't count the weekends, and I don't count the holiday. I think at one point I had one situation where I was looking at the 7. The 7 ended up being equivalent to 12 because the way the timing worked is I got a couple of weekends involved with it somehow, and I forget how it worked out that way. But the fact is that the 7-day response was provided more time than the 10 because of the way in which the days were computed. And that's obviously you need to know how to compute those at times, because there will be people that will sort of time that. And I hate to say it like that, will be people. There are times where I have timed it, not to ruin someone's weekend, but because that worked for me more than worked necessarily for them. And so, because that's the other part of it. When you serve, then you got to recognize that, well, okay, I'm going to get a response by sort of X date. What's my schedule look like in case I want to file a reply to that? So all of this becomes part of the things you consider. Let's now, after having discussed our controversial surrogacy cases, let's turn to something less controversial, like how would you value the birth of a healthy child? And this is Burke versus Zaribo case. Causing the birth of a healthy child and the parent sued for damages. And I always like this case. Does anyone think that this case is just really bad public policy? I mean, Mom and Dad didn't like you so much they sued the doctor when you were born. That doesn't create a fair amount of baggage to have to carry the rest of your life. I mean, my brothers and I would taunt each other, but this is, they really didn't want you. Like, no? And how do you value it? I mean, what's the kid worth? Because that's what we're doing. We're going to put a value now, a price tag on the birth of the child. So, Mom can sue. Go ahead, Gary. Get us started.
I'll start it. I guess the hard part was in the dissent where, what's her name, said that it's almost putting the burden on the parent to prove how much they don't like that child. And that's where I think, that's where it stuck out for me is...
How much they didn't want the child.
Yeah, they would have to kind of really have to prove that. And that almost encourages the breakdown in the relationship potentially. So that's where it gets funky, I think.
What's the value? How do we arrive at the value?
I think that numbers might be easier if you do financial calculations like you do with child support. You could probably do that. But where it crosses the line is when you say you don't want the child. That's different.
Well, don't they have to? I mean, they don't get to sue at all if they wanted the child, right?
They'd have a harder time prove that.
Well, they don't have damages, do they?
Yeah.
If they want the child, they wanted the child, there's no damages there. So now you got the child. You want it. Because the court does make a distinction between people who choose not to have babies for financial reasons and people who choose not to have babies for health reasons. Because there is a difference there, isn't there? Those that choose not to have babies concerned about genetic disorders, but then get a healthy baby, they don't have damage, do they? I mean, they owe, don't they? Don't they?
They owe?
Yeah.
Just pay extra.
Well, this gift we just gave you.
They pay a doctor more.
No, right? You chose not to have it. We just finished these cases where people paid $100,000 or more to get a child. Well, if you're saying that you were concerned about having children because you were concerned about raising a child with genetic issues. And that's why you went and had this procedure. But lo and behold, you have the perfect child. How about a little thank you? If I'm the doctor, how about a little thank you? Right? The reason you chose to have this procedure, as it turns out, wasn't valid. I've given you something that you wanted and now want. There's no damage, is there? And what is the damage anyway? So is it all the money to raise that child to what? 18? 21? College? So it is.
Adulthood.
Yeah.
Adulthood,
Yeah.
which includes college?
Yes,
So Doc is going to pay for college.
you bet.
And everything in between?
Yes.
Sneakers, sports camps,
What if he's a really good athlete?
You
clothing,
can keep your fingers crossed.
everything.
Yes.
Because but for doctors' negligence, malpractice here, we wouldn't have spent a dime.
Correct.
Therefore, we're going to look at whatever it costs, and it's a lot. Right? Patrick's got 2 little ones now, right? You haven't begun to pay, Patrick.
If I'm going to go to the doctors and say that I don't want to have any more children, and I have this procedure, and then I pop out a kid, there's a problem here for me.
Okay, we agree. Well, we agree there's a problem.
Yes.
Everything is on Doc?
Everything.
Everything.
Yes.
Baby food, spoons,
Everything.
crib.
If I have my way, yes.
No, but if you have your way, the case talks about this, right?
Yes.
If you don't hold the physician accountable, then you're going to, public policy standpoint, you're going to promote families that can't afford this child to abort. So,
Well, can I ask about that? I mean, you didn't want the kid. You don't want the kid so badly, you're not going to sue. Why don't you abort it?
Ask Sunshine.
I mean, you have generally have an obligation to mitigate your damages, don't you?
Because I don't believe in that. That's
Oh, you don't believe in aborting a child. You just do believe, though, in holding someone else responsible for the birth of your child.
Because
Financially
I
responsible.
went through a procedure to say that I didn't want any children. And you need to bond.
Listen, okay, then even a better solution. You don't have to have them. Give them up. Give them up. So you give them up. So now you still don't have damage other than your medical costs for those 9 months. Well, give up the child. No,
You can do that, but
huh?
you
Well-
could do that.
You could. So then you still don't have damage, then, do you?
But now you have an attachment to this child.
Doesn't sound like much of an attachment to me, frankly.
You didn't want it, but now that it's there, you have an
Little
attachment. You don't
bird bonding,
want
not
to
too
give it
much.
I
up.
want to just, yeah.
Well, why not, though? I guess you don't want to.
It's like, you know,
I'm wondering
it's
whether
like
you
the
don't want to give it up in part because I'm looking at a couple $1 million from Doc.
That's not right.
What's not right?
What you just said. That's
Well, I can see why you'd reject it, but you want the child and you want the money. And where we know you could give the child up for adoption, and you said you don't want it, the people that do. I mean, if you really didn't want it, and are you saying you still don't want it? Because that doesn't sound like you'd make a very good mother, frankly, then. No, right?
I agree.
Okay,
Mother, but
so can you give it up? Or can I make you give it up? You're saying I can't make her abort the child.
no.
Why is that, out of curiosity? Because that's one of those sacrosanct areas. Professor Rednick come up here and beat me up with a
That's
baseball
right. That's
bat
right.
if I keep talking like that.
That's right. Fundamental right. Yeah. She'll come up and kick it.
But I guess, does it not impact, does it not strike you that this fundamental right that you guys flash around like this is sort of used to prevent us from having any say in the process, or prevent poor doctor from having any say in this process now?
He did a procedure on a woman that was supposed to tell her that,
I messed up. I messed up.
I messed up.
I did, I'm afraid.
Malpractice, I'm going to sue your ass. That's what it is.
Okay, listen, I'm giving you all that. I'm conceding that, right? There's clearly, I can't imagine he made the promise that it appears, but that seems to be a given in the case, okay? He said, you'll never have to worry about this issue again. I'm giving you liability. I now want you to establish the damage claim. And I guess you're telling me everything is responsible, right?
Yes.
Because but for your mess up, I wouldn't have incurred any of these expenses.
it's
Yes.
like the doctor is adopting the child.
Right, the doctor is going to adopt the child, financially certainly. Let me ask you this, go ahead.
I was going to say, I think in the case they said, yeah, you're entitled to that, but you have to offset it by the fact that you have a healthy child.
Okay.
And the joy that comes along.
Let's talk about that. So you're going to tell me how you arrive at the number, and you're telling me the number is arrived at by looking at every dime we would spend from formula and diapers to college. Everything. Really, like Snickers bars after school.
Everything.
Everything. So you don't intend to provide a dime of support for this child, right? No, logically, this is the
That ain't gonna happen.
Wait a minute. Why not though? Her argument is, but for the doctor's negligence or breach of contract, I wouldn't have this expense. So her top number is everything. Because here's your problem. If it's not everything, how are you going to pick and choose which ones it is, right?
I mean, your Snickers for after school snacks.
She says the Snickers too. Yeah, that's right. She
You don't have Snickers for after school snacks.
Snickers. She's saying everything. I'm not going to give this kid a thing.
I think your
I'll give
moral
you an
compass
example.
will not allow for that to happen, though, because your mother, although you don't want the child necessarily, I think something happens along the way, and you're like, you know what? Although this was this doctor's, I didn't want to have children, but obviously, there was something.
I think you have to concede you didn't want the child, but want it now.
Isn't it the same as if you look at, as an example, if you look at, like, you have a baby and the baby, it becomes an issue, becomes something wrong with it.
Yes.
Isn't it the same thing? So the doctor, you prove that the doctor made an error, so you're going to sue the doctor, and you're going to get, from the time that baby's born till his future, that doctor's going to pay. What's the difference?
Well, is the doctor going to pay for everything, or is the doctor going to pay for the additional expenses as a result of the doctor's negligence? I mean, you still would have had to buy a crib. I shouldn't have to pay for the crib. I may have to pay for a special crib
guess
now
it
that the
depends
child
on the
has...
attorney.
What?
Depends on the attorney that's fighting for you.
No, but let me just ask, let me just ask seriously, because the last part of this, we start to look a little more closely at damage issues and the like. In the situation you described, you don't get a crib, right? You would have had a crib anyway. What you get is the additional, if you need a fancier crib or a different mattress because the child has certain medical issues. That I pay for, but I don't pay for the crib. Do I? I don't pay for the baby's clothes. You would have bought clothes anyway. I pay for the baby's bandages. Right?
Yeah.
There are certain expenses you would have incurred anyway, whether the child was healthy or not. What you're saying is, I've incurred additional expenses because the baby is not healthy, and it's not healthy as a result of your negligence. It's the latter I'm responsible for, not the former. Right? In this situation, you're saying, no, in this situation, there'd be no baby. You're responsible for everything. That's the argument. And it's not just an argument, I think that's what the court is saying, at least at the outset, and then we're going to look at the offset. Go ahead, hello.
Parents could be compensated, like, as an award, like, I'm sorry, it's a negligence, but not in the long run, because the child could be affected by knowing that he's, parents are getting paid to take care of him,
Well, so you're going back to the policy issue that I asked about, is that, I mean, this really is, I mean, kids can be cruel to one another. Imagine if we were sitting here reading and said, Ash, isn't your last name Burke? But so, I mean, right? I mean, this does raise sort of issues about along those lines. Go ahead. What were you going to say?
I was just going to go, I was going to agree with a little. The baby's going to grow up saying, okay, I understand I'm a mistake, but now you don't want to pay, for anything,
Well, I think ideally, the kid shouldn't know about it. You'd like to think it was settled and done, and it doesn't get brought up to the child or anybody else.
I'm surprised this case wasn't labeled differently, like without the names.
The AC versus whatever, yeah. Well, but again, there is a preference for public process. Let me ask you this. He raised it. Suppose the big number is everything you say. There's got to be an offset. Children are of some value to us, right? Personally. Right, Pat?
Cut it by 50%.
So the credit is, so if the cost of raising the child till, and I think, assuming the parents went to college, I assume you're saying it's college. Is that true? Assuming the parents didn't go to college, it's 18. But can we agree with that? Or are you saying, no, this child would have done better than her parents? So it's.
Why can't they?
What?
Why can't they? Just because your parents are going to college doesn't mean, my parents didn't go to college. I went to college.
Okay, but you've got to create a damage model, and I agree. So does your damage model assume this child was going to go to MIT? Because, I mean, there's different, right? I mean, I understand what you're saying. I'm wondering how I can accept the damage model that says, oh no, this one would have got a doctorate. Well, no one else got one before. Right? I mean, to some extent, and I recognize oftentimes the children exceed the educational level of the parent. You got to sell that, though, right? It's your obligation to prove both liability and damages. And at the minimum, I think you could say it's likely to be equal. When you go beyond that, and I agree, so you got to try and show why that is. What if, well, his other two siblings went to college? That may be more indicative than what the parents did. But we probably all got siblings that did or didn't go. Bill Gates didn't go. Not that that means much of anything, right? Since obviously there's ways to make a lot of money other than going. Suppose your top number is $1 million. Kid's worth something, isn't it? See it? Even those two that got in trouble? Aren't they? No, aren't they? Don't they bring some joy into your life?
Depends on the good days versus bad days.
So, and they're both, right?
Yes.
But so how do we value that? Okay, now you've figured out the value of the cost. Now, because the court does say the doctor is entitled to a credit for the offset value that you've received. So what's that value? Hello, what's the value? What's the value of going home and seeing those? How many? You have 2 or 3?
I have 2.
Those 2 little ones.
There's no number.
There's no number.
It's infinite.
So what's that? She says the number is so large she can't offset it. You're back to 0. Huh?
You said there's no number.
She didn't say
No,
zero.
there's no
She said
value. Like, I couldn't give you a number because my
But it's not
kids.
zero.
Talking about my kids.
It's not 0.
No, of course it's not 0, but I'm saying there's no number meaning like.
No, but this is going to cost you. There's no amount of money you would sell those children
Right.
for.
There you go. Thank
They're
you.
priceless.
Priceless.
So therefore, the value far exceeds the cost.
There's no amount of money you could have paid me to voluntarily get pregnant, though.
That's right.
Not you, Pat.
That part sort of threw me too. I wasn't quite sure what to do with that.
I don't know if you can handle it.
Okay, but I need your credit because the court says I get the credit.
Right.
Because you had a very easy time figuring out all your expenses. What's the value? Right? Yes. Does heartache come with it at times? Sure. Right? Trouble? You bet. But at the end of the day, we all still, many of us still have kids
They wouldn't
because...
have the heartache and the trouble if they didn't have the baby. They wouldn't, none of that.
Right.
They wouldn't have anything. That's the whole point of her going to have.
They wouldn't have anything. But what we do know is they've got that.
Sunshine.
They also have some good days.
Right.
Lots of good days. So tell me how we value that, because the court says I get a credit. And by the way, the court does make this distinction between, at the top of my book, it's 772, between parents who desire to avoid the birth of the child on eugenic reasons, because they're worried about birth defects, or money. It says, and if a healthy, normal baby is born, the justification for allowing recovery of the cost of rearing a normal child to maturity is far less. When to conserve family resources, the parents sought unsuccessfully to avoid conceiving another child. That cites the Arizona case. Right? So, I mean, does anyone feel kind of icky about this notion that we're going to value those children differently depending on whether they're healthy or unhealthy under the circumstances? I mean, because you guys were all sort of worried when we talked about the surrogates, this whole march for building a super race, and now we're going to sort of vary the value and the cost of this child depending on whether they have any type of disabilities and the like. I mean, gee, is...
I could see another challenge. Let's say you were suing a doctor for his negligence in performing birth and some kind of defect happened to the baby, and then the doctor said, well, hey, in 5 years I can do an operation, it might fix him. So we can give you damage up to year 5, but if I'm successful fixing him, what's the value after that in this lawsuit?
Well, but you'd be entitled to the cost of the surgery, but then your damages would likely be less, right?
Or if I'm partially successful, what's it worth?
Does she enjoy the child with disabilities less than the healthy child? I mean, her value, is the value to her, because I'm still looking for my credit, is the value to her, or to all of us, different for the healthy child versus the child with disabilities?
The value is no different on...
Shouldn't be, right? When we say that from here,
Right.
What's the law say? What does the law do with that?
Still work though. You
Still
come
won't
up with
work?
the same.
So we know intellectually that we shouldn't be creating that, but we think legally we are going to as a lawyer, right?
But if there's a disability, then the cost of raising that child is going to go up.
I don't disagree with that. So now we'll add to your costs. What I'm asking is, I'm still looking for my credit, Pat. I want to know, some of you will represent the doctor here, right? Some of you are going to...
So according to this case,
Some of
correct me if
you-
I'm wrong, any negligence that a doctor does, they get a credit? Are you kidding me? Really?
Well, not any negligence. Here, this is, you're saying, but for the doctor's negligence, we wouldn't have this thing to take care of, right?
Right.
Okay. And so you expect to be reimbursed for all the costs attached to that thing, okay? Now, and what I'm saying as the doctor is, first of all, you don't have to be so attached to the thing, because there are other people out there who would welcome this child in their home and not seek a dime, frankly, would pay for a healthy child. And B, well, see, this is the problem with the thing argument is, and B, that person, as has been said, has to bring some light into your life, even on their worst days. All of those of us that are parents would not likely say, I'd never have that kid again. Right? Sam, come on. Even on their worst days. I mean, I wish you were never born. I hope not. I don't see.
No.
So, okay. So even then, we know that they, after a hard day, you come home, there's still someone glad to see you, right?
Yeah.
Now it's my puppy. He's not a puppy anymore, he's 2. My kids are too old.
I'm happy to see you.
Yeah, I know. You don't fall asleep on my ottoman while I'm watching TV. Scout does. So what's the value, and how do we figure out that value? Because it's got to be something. We've got at least half as much. If you say it's $1 million to cost, the value is at least half. Aloha says, if the cost is $1 million, I think it's $1.5 million value.
Yeah.
Because we don't engage in this whole process for financial purposes anyway, do we? I mean, we want to have children. Those of us that want to have them, and those of us that don't, hopefully don't. So they're saying I get a credit. I want to know what that was worth. $50 a day? $100 a day?
You're really asking the wrong woman over here,
No, I don't think I am actually. What?
I really don't. I don't understand how I know the court's saying that he should. I don't understand how he should. He made the error.
I'm giving you that. I'm giving you all the money to raise it, right? I'm not disagreeing with your count. I'm asking you, and what is the value of what you received? That's all. Are you seriously going to hold the line and say it is 0?
In other words, is there any credit offset to the doctor?
Since you want to keep...
No, I'm asking her, is there any positive value to what you received?
Any positive
With this child.
offset?
Any positive?
Absolutely.
Okay.
Absolutely,
There is.
yes.
How much?
How much, right? How much is that worth? That's because that's what the credit
A
is.
lot. It's worth a lot.
Then-
Okay, here we go. Now we're on the same page.
Worth a lot, but it's not dollars.
Right, that's what I'm saying, I can't,
Shouldn't the damages be based on the mother, not the kid? The mother,
It's not.
you know,
I can't buy the kid a college education with my love.
Yeah, you just, yeah.
But you're already gonna get that. It's the offset, that's the hard
Well,
question.
that's how, right, so that's why we're having a trouble calculating an offset.
So you have no problem valuing the damages. It's just what the value received to you. Oh, geez,
Well-
I couldn't be so crass as to put a dollar value on my child. Oh, you had no problem putting a dollar value on the other side.
Well, yeah, because you're talking about health
Actual
care, you're talking about
expenses.
education, you're talking about clothes, food, housing,
That's easy.
Snickers.
And now we're talking about use and enjoyment. We're talking about quality of life. And we're talking about, you know, if the antonym is pain and suffering, we're talking about joy, pure joy. And I want my money. And the case says I'm entitled to it. So I understand you're having difficulty with it. You have no problem putting your hand in my pocket. Well, I want to put my hand in your pocket, and I want to get some value for what it is you received as a result of the favor I did to you.
Favor.
You have what we just spent weeks time reading, where people would go through extraordinary anguish and medical procedures and expense to have what you have.
happened to my parents. I was in an accident. My mom had that too. Yeah, I was in an accident. Here I am.
I wouldn't say you're an accident.
No.
I was planned,
Took a couple
but
days.
Okay.
not medically. I was not.
So, and my guess is her parents wouldn't give her back for anything.
Or at least the grandchildren.
So
You know,
Can't try now. Yeah.
So you got to give me a credit. The case says I get a credit.
5% of the judgment.
5%. I had 50%. I think.
yeah, you're too easy.
Well, think about it, like,
Why do people have children if they're so expensive?
I have no idea.
I have no idea.
At least you're all being. Why?
So then
Various reasons for lineage, for joy,
Yeah, well, for joy, for why do people get married?
for lineage. You know, you want someone to.
carry on the
Companionship.
name, all that
Huh?
kind of stuff. Carry on the name.
Legacy.
Well, is carrying on the name of some value? Is that important?
Oh, some
But if
guys.
you're wealthy,
Sometimes I know. No, really. You guys. Let me ask you another question about this case that struck me a little bit. You read the dissent. O'Connor, Nolan, Lynch. Three good Irish Catholics. Does that weigh into? Do you think their religious beliefs influence the outcome of the decision?
Why? Doesn't say.
Probably
Does it
bias.
not strike you as odd that three Irish Catholics on the court write the dissent? I'm wondering. I mean, okay. Here's the real question: do your religious beliefs affect how you would work on a case, or
Absolutely.
absolutely will?
Yes. Yes, for me, yes, personally, yes. Yes. Sorry, just.
Well, I mean, because look at this, and I think you really think this is a coincidence that the dissent comes from these three. By the way, Justice Lynch is one of our trustees. He's a great guy. Nolan I like. I don't know O'Connor, but Nolan I like. I've had him for some mediations when he was in federal court. Really interesting guy. By the way, 8 kids. Seriously, 8 kids. Nolan.
wow.
So who we appear before, that potentially influences their religious upbringing and their religious beliefs, potentially find its way into our cases.
Look at the Supreme Court, it's always 5-4.
So, someone suggested one time when I asked this question before, is that well, is it a surprise when if we look at a lot of our laws, certainly our blue laws, right, in Massachusetts, their origins really have more to do with, less to do with civil law than church law. No drinking on a Sunday, why was that? Well, that really didn't have as much to do with civil law as to what the ministers and the priests wanted of us. So is religion and law, even in this country, are they intertwined like that? I mean, because we sort of reject that notion when we see it elsewhere, so no, that shouldn't be. But is it? And Sandy says it's going to affect her here.
Yeah, I mean, law,
It is, it's there, it's intertwined.
law and legislation don't happen in a vacuum, you know? You've got to be influenced.
Does it influence the present debate? Right? Being married in the church. Church law as to who can marry is one thing. Civil law is another. DOMA, is DOMA an intrusion in sort of that mixing of what our religious beliefs might be about who can marry as opposed to what civil law should provide? I'm just throwing out questions. I'm not looking to really poke the bear here and have you all just...
Let's do it.
No, I want you. I just want you to think a little more about some of the issues that I look at this and I think that really isn't a coincidence that these three lined up in dissent to say, I'm not even sure you should be putting a value on human life, period, financial or otherwise, what's it say? Tort law finds its source in social values and ought to promote appropriate public policy. In my view, it would be equally intolerable for a judge or jury to engage in an inquiry concerning the probable value of a child to his or her parents. The result, in my view, is that child-rearing costs should not be recoverable. As Sandy said, that it doesn't quite seem fair, but for the doctor's negligence or breach, we wouldn't have any expense. But we do. But then now you've got to value what you've got coming back. Go ahead.
So, I mean, to be a good lawyer, in my opinion, you have to make sure that you don't get caught up in black letter law all the time. You have to be a good psychologist to be a really good lawyer. The better you understand people, and including, in this case, judges, the better you're going to create your argument. As a lawyer, and like Sandy was saying, you're not going to want to take certain cases, of course, and let's face it, I know people are going to get mad at me, but some people get mad at me when I say that if you
Females, I think.
No.
Okay.
No, I'm just this one's generic, not even political. If you don't really feel really good about your client or the case you're with, you're not going to work as hard. You're going to give a competent professional job, but you're not going to go beyond the workload that, you're not going to go work nights and weekends and extra hours. And the judges are thinking the same way. You've got to understand, if you don't give a good argument to a judge, or if he doesn't like you, or if he doesn't, if he or she, you better realize if you get certain judges that are Catholic and Irish, you better realize those things in the real world. They're going to affect your case.
Right, the makeup of who sits up there matters. Right? I mean, I don't think we can be unrealistic about that. We hope that people put their biases, don't look at it as the negative bias. We favor things, right? We favor things. That's the way people are by human nature. The negative to that is
we discriminate.
Well, we don't like that
Between
word
hot and
either.
cold,
We have things we favor. We have things we like to a greater extent than
Good
things
and
we
bad,
dislike.
hot and cold, that's discrimination.
But the fact is that we put a robe on doesn't change what we favor, and so you got to think about how do we appeal before the person that we are there before, and I don't totally reject what Gary says about will you work as hard. But that analysis has to be made before you take the case or not. Because I do think his point about there will be some that you will give more than you possibly can give because you so passionately believe about that client's cause and and whatever it is that's before you. And if you can't do that on every case, then maybe you shouldn't be in the case. And that's where we part ways, because I hope you get to work on cases that you passionately believe about, because I do not believe in passionless advocacy. But in for a penny, once you're in, and that's where we part ways. But I think what he says is a good caution, because the multiple child molester who somehow I've got stuck on the case, I would struggle with working for that person. But that really means that that means at the outset I need to recognize that and say, I'm really not the lawyer for you, because that person is still entitled to the one that's going to work on the weekends and everything else. Go ahead, Ash.
On the same token, if that's clear to your client that you're not willing to be 100% dedicated to their case, then he may have an action against you.
Yeah, well, right. I was just going to say that. I didn't know where you were finishing that one. Where do you think that ends, right? Listen, I'll take care of it. Don't worry. I know what I'm supposed to do. But it's clear your heart isn't in it, and you're not doing much of a valiant job. When things go bad, as it appears you desire, what do you think happens with that client who now blames you for what's taken place, not their own actions? And Ash is right. That's the other part of it to think about.
I was going to say pretty much the same thing. Whereas, ethically, if you don't want to be on the case, you tell, listen, take me off this case. You go to the judge. We were doing a case in ethics class where a guy was asked to defend the direct secretary to Osama bin Laden. And he was like, listen, this guy doesn't want my help. I really don't want to help him. And they're like, you know what? He's entitled to it, and you're going to do the case. So, and he just sat there, didn't give him any argument or anything. But he still made the effort to take himself off.
Well, but see that's where I think you got to recognize is that if you're in some cases you'll get stuck in, then the effort has to be the 110%.
That's not the point I was trying to make. The point I'm trying to make is even if you pick your cases and you only take cases you like, you're still going to have some that you're going to work harder than others. That's real life. That's real people. That's what I'm thinking.
I don't disagree with that. I don't know whether that's appropriate, but I don't disagree.
And a judge is going to do the same thing. There's going to be certain lawyers, no matter how professional a judge tries to be and how neutral the judge tries to be, there's going to be certain lawyers and certain cases and certain things and certain religions and we're real people is my point. Everybody's affected somewhat. They're going to work a little bit harder in some cases than others.
Okay, I got to do Mark versus Karen. So listen, my wife's name's Condarelli and mine is Coyne, obviously. So we get divorced, and she can change the name of my kids to Brady, her new husband, or worse yet, Condarelli. She can make them Condarellis over my objection. Can she? Did you say no?
It's Brady.
Huh?
You might stand and get some. I wouldn't be mad about it.
No, but the children's names could be changed over my objection if the court thought that was somehow
Depends.
in their best interest.
Depends.
What do you mean? Depends on what?
Well, I think in this case it said, first of all, the reason why the names were getting changed was because she was angry at him or something. Did you not?
Well, that's what he says. But she says, no, this is because we have a blended family now, not uncommon, right? Brady Bunch. And so we all want to be Bradys. We all want to be Condarelli Brady. What the hell? They're coins. Right? They're coins. They're Ben coins. They're coins. Can the court do that over my objection? Because listen, here's the thing. If it's not for spite, you really think someone's going to be dumb enough to get up and say, no, it's for effing spite? change the names. No one's going to say that. Oh no, see, he has some children, I have some children. We want them to go to school together. People say, isn't that your brother? How come he's got a funny name than you? Bah, 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 bah. There's a million reasons we can manufacture here. But at the end of the day, they're not going to be coins by the time she's done. Does the court say she can do that?
Leaves it open. I think the year of this case plays a lot into it too. I mean, in 1956, divorce was frowned upon. I mean, I know from my family history of how that all went down and how people are supposed to pretend who their mothers are and go use a certain name and whatnot. So I think that the year nowadays, I don't think it would be that much of an issue. But back then, I could see why they kind of left it open, even though I think the father had a legitimate issue with this.
But even with the legitimate issue, at the end of the day, the court could decide, we don't accept that,
Right.
and we're going to change it.
Right.
Could the court change the children's religion over my objection? Why not?
It's ultimately up to the children or the
Well,
parents.
if they're little kids. No, listen, I don't go to that church anymore. We don't belong. We are now whatever we are. And I'm the one taking them to church.
State can't
If he
influence.
cared that much, he could be taking them to church. He doesn't. He goes and watches football on Sunday.
State can't influence that.
No, the mother can, though, right? The mother says, I want to...
She has custody.
Yeah.
She has custody. I want to change their religion to X. And I find out about it, say, no, this is not happening. Can the court nonetheless allow her to continue to take children to temple or to a different church than that?
In that case, hire a guardian ad litem? Is that
Yep. The court might appoint a guardian to determine whether this, in fact, is true. That this is where they go and this is what's done and it's a nearby church. But at the end of the day, that probate court still has the power to even do that over my objection.
Yes, because
Yes.
the mother has custodial rights. She can make all the legal decision-making and, what school or what,
They're going to look at who was the religion provider during the course of the marriage, and they can, in fact, do that. Knighton versus Knighton, can the court issue an injunction preventing the husband from engaging with his paramour? Court said here that they will not normally enjoin the commission of a crime. Equity does not enjoin the commission of a crime. It is adultery, and the fact is it's a little difficult to try and get someone to stay with his wife, and that's what she wanted. And then the last case in this sequence is the Edgar case, and this gets us into contempt and the like. And that is the remedy for violation of the probate court's orders, or any order of the court, is in fact contempt. And I thought this was interesting as these cases shook out, because it talks a little bit about you can have criminal contempt, you can have civil contempt. And obviously, depending on whether we have civil or criminal, the rights that attach to that type of contempt action will be different. And so, at the end of the day, a party in contempt, whether it's civil or criminal, may well have to pay the attorney's fees involved for bringing that action forward in order to enforce the court's order. But I thought the Edgar case was interesting because it talks a little bit about those different processes. It also talks about, frankly, that the court doesn't necessarily, once it's set, doesn't have to give you a lot of time for trial. They gave him a small extension, but at the end of the day, if we're there, you should be expecting to try the case and ready to try the case. And I think they were trying to force a settlement a little bit, but at the end of the day, they can go forward with the contempt proceeding.